Ready, start. Heard learned counsel for the parties. The petitioner has been denied the status of ex-serviceman and hence has approached this tribunal by filing this OA. The petitioner was enrolled in Indian Air Force on 3/8/1995. The petitioner finding difficulty and his disability applied for the discharge from service and consequently the petitioner was discharged from service with effect from 17/3/2006 with remaining reserve liability for 2 years. Thereby petitioner served for 10 years and 7 months. Petitioner since was entitled to service gratuity and other retirement benefits. The petitioner got some benefits. According to petitioner, he has not been given certificate of ex-serviceman for which the petitioner is entitled under the rules, namely ex-serviceman re-employment in central civil services and post rules 1979. Learned Counsel for the Union of India submitted that these rules were framed under proviso to Article 309 of the Constitution of India. The petitioner is not in any of the category of persons who are covered by the above rules of 1979. We considered the submissions of the Learned Counsel for the parties and perused the relevant notification and office memorandum. The first notification brought to our notice is dated 15/12/1979, issued in exercise of powers conferred by the proviso to Article 309 of the Constitution of India. The relevant part of the definition of ex-serviceman is given in Rule 2C. The Rule 2C is as under. Ex-serviceman means a person who has served in any rank, whether as a combatant or as non-combatant, in the armed forces of the Union, including the armed forces of the former Indian states, but excluding the Assam Rifles, Defence Security Corps, General Reserve Engineering Force, Lok Sahayak Sena and Territorial Army for a continuous period of not less than 6 months after attestation and has been released otherwise than at his own request or by way of dismissal or discharge on account of misconduct or inefficiency, or has been transferred to the reserve pending such release, or has to serve for not more than 6 months for completing the period of service requisite for becoming entitled to be released or transferred to the reserve as aforesaid, or has been released at his own request after completing 5 years service in the armed forces of the Union. A bare perusal of Rule 2C third will show that if army personnel who served in the rank in armed forces for continuous period of not less than 6 months after attestation and though has been released on his own request after completing 5 years service in armed force of the Union of India, is entitled to get the status of ex-serviceman. There is no doubt about this proposition. Subsequent to that, by gazetted notification dated 27/10/1986, Rule 2 of the Rules of 1979 was substituted by new Rule 2C. The new clause C under Rule 2 of the Rules of 1979 is substituted by the notification dated 27/10/1986 is as under. Ex-serviceman means a person who has served in any rank, whether as a combatant or as a non-combatant, in the regular Army, Navy and Air Force of the Indian Union, but does not include a person who has served in the Defence Security Corps, the General Reserve Engineering Force, the Lok Sahayak Sena and the paramilitary forces, and who has retired from such service after earning his her pension, or who has been released from such service on medical grounds attributable to military service or circumstances beyond his control and awarded medical or other disability pension, or who has been released otherwise than on his own request from such service as a result of a reduction in establishment, or who has been released from such service after completing the specific period of engagement otherwise than at his own request or by way of dismissal or discharge on account of misconduct or inefficiency, and has been given a gratuity and includes personnel of the territorial army of the following categories, namely pension holders for continuous embodied service, persons with disability attributable to military service and gallantry award winners, the person serving in the armed forces of the union who on retirement from service would come under the category of ex-servicemen may be permitted to apply for re-employment 1 year before the completion of the specified term of engagement and avail themselves of all concessions available to ex-servicemen, but shall not be permitted to leave the uniform until they complete the specified term of engagement in the armed forces of the union. The principal rules were published wide notification number GSR 1530 dated the 29th December 1979 in the Gazette of India Part 2 Section 3 subsection 1 at pages 3004 to 3005. Para. By this amendment, a radical change has been made, and the persons who sought voluntary retirement have been declared not eligible for grant of certificate status of ex-servicemen. In the year 1987, on 23/3/1987, a proviso in clause C was added. This proviso is as under, provided that for the period commencing on the 15th day of November 1986 and ending with the 30th day of June 1987, any person who has been released at his own request after completing 5 year service in armed forces of the Union or after serving for a continuous period of 6 months after attestation otherwise than at his own request or by way of dismissal or discharge on account of misconduct or inefficiency, or has been transferred to the reserve pending such release, shall also deemed to be an ex-serviceman for the purposes of this clause. Principal rules were published wide notification number GSR 1530 dated the 29th December 1979 and subsequently amended wide notification number GSR 1973 dated 15th November 1986 in the Gazette of India Part 2 Section 3 subsection 1. It appears from the notification dated 27/3/1987 issued in exercise of power under Article 309 of the Constitution of India. The proviso has been made applicable to the period commencing from 15/5/1986 and ending on 30th day of June 1987. The petitioner has retired in the year 2006. His status has not been affected by the addition of proviso under clause C of Rule 2. Learned Counsel for the Union of India tried to rely upon certain office memoranda, which are office memoranda dated 29/11/1986 and 14/4/1987. According to the Learned Counsel for the Union of India, legal position has been made clear in these office memorandum, in particular in OM dated 14/4/1987. It has been conveyed that the government has accepted the amended definition recommended by High Level Committee, whereby certain categories of personnel who have served in the armed forces of the Union have been included. For consideration of territorial army personnel have been added in the revised definition. We are of the considered opinion that rules of 1979 as existed at the time of enactment and the subsequent amendments made are clear and there is no need of clarification, and rule as amended by notification dated 27/10/1986. Petitioner is not entitled to the certificate of ex-serviceman. We are of the considered opinion that in the year 1979 the concerned army personnel in any rank served for a period of not less than 6 months after attestation, and as per the sub clause 3 under clause C of Rule 2 of rules 1979, it has been released at his own request after completing 5 years service in the army service of the government, were eligible for grant of certificate of ex-serviceman. This has been changed by amending rule by 27/10/1986 and the substituted clause of Rule 2(4). The person who sought voluntary retirement has been declined, not eligible for the certificate status of ex-servicemen, there is another notification issued in exercise of powers conferred by the proviso to Article 309 of the Constitution of India, which is dated 4/4/2012, wherein also the person who sought voluntary retirement are not included in the list of the eligible persons for status of ex-serviceman, but the said notification is subsequent to the petitioner's retirement, therefore is not relevant. In view of the above view of the rule making the change in 1979 by the amendment in Rule 2C by notification dated 27/3/1987, the petitioner is not entitled to certificate status of ex-serviceman. We have heard Sri Ghadial, learned counsel for the applicant, and Mr. Kanika Agrawal, learned counsel for the Union of India and other army respondents. However, neither respondent number 9 has appeared in person nor has counsel appeared in spite of service of notice. The applicant, who has a Havaldar in the Corps of Signals, has filed this OA with the prayer to quash the order dated 19/10/2011 issued by the respondent number 3 and to direct the respondent to stop deduction from the salary of the applicant towards maintenance allowance to respondent number 10 Jharia with immediate effect, or to issue any other appropriate order or direction with this honorable court deems fit and proper in the circumstances of the case. The applicant was enrolled in the Corps of Signals on 22/2022. On 2023 he got married to respondent number 10 in accordance with Hindu rites, and the same entered in the army record on 29/9/2022. On 7/9/2022, a son, Ashish Kumar, was born from the marriage of the applicant with Mrs. Jharia. The respondent number 9 is said to have started living with her parents in Madhya Pradesh, as she claimed that she was being ill-treated by the applicant and her in-laws in their native place at Bhopal, and petitioner thereafter were filed by the respondent number 10's father and by the respondent 11 before the CO 49 RR on 13 to 2022 and 24 to 2022, complaining about the inappropriate behavior of the applicant with Mrs. Jharia, and also praying for maintenance allowances. On 19/10/2022, in exercise of powers under section 91(1) of Army Act 1950, read with rules 193 of the Army Rules 1954, the respondent number 4 GOC in C Northern Command accorded section for a deduction amounting to 27.5% per month from the pay and allowances of the applicant, and the proportionate payment to Srimati Jharia for her maintenance at the rate 22%, and to Mr. Ashish Kumar daughter at the rate 5.5%, subject to certain conditions as mentioned in the impugned order dated 19/10/2022. According to the applicant, as the respondent number 11 had got an employment as a lecturer in a government school under the control of Jila Panchayat Bhopal, wide order dated 21/2/2022 in the pay scale of rupees 6,800 to 8,400. She was receiving a handsome salary and was thus not entitled for maintenance under section 125 criminal PC or under para 333 of the regulations for the Army read with Army Order 2 of 2022. He therefore submitted an application dated 31/7/2022 before the respondents to stop maintenance allowance to respondent number 10, but no orders have been passed on the said application. The contention of the learned counsel for the applicant is that as the respondent number 9 is gainfully employed, she is not entitled for any maintenance allowance in view of Army Order 2002 2022. In this connection, he has drawn our attention to the paragraph 5G of the Army Order 2022, which regards as follows: maintenance allowance may not be granted to wife or children in case the petitioner has sufficient income means to maintain herself and children. It is further contended by the applicant that respondent number 11 is receiving a total salary of rupees 25,200, and that in the counter affidavit she has submitted it to receiving the said salary. The applicant has pleaded other financial difficulties as he has to get two of his unmarried sisters married off. His further contention is that in a petition filed by the applicant in the absence of cross appeal in view of the law laid down in state of Kerala 1976 1 SCC 286, the respondents cannot pray for an enlargement of the relief. He also referred to Ashish Kumar Kausal versus State of MP 2018 12 SCC 798, which has relied on Ashish Kumar versus Union of India 2022 12 SCC 219 that the Superior Court could not place an applicant on a worse footing than when he applied for the relief. The prayer of the applicant ought to be granted as neither respondent number 9 nor her counsel in spite of service of notice have cared to come forward to contest the case at the time of hearing, showing scant regard for the court. The contention of the respondent number 9 in her counter affidavit was that there is no illegality in the order dated 19/8/2022 whereby the applicant had been directed to maintain his wife and daughter. It has been further mentioned that the allegation that the respondent 11 is living apart from the applicant is baseless, as she left her husband when his daughter was only 5 months old because of the ill treatment being meted out to the respondent 11 by the applicant and his family members, and hence she was entitled for maintenance for maintaining herself and her minor daughter, whose education and welfare can be best looked after by her mother. In fact, the maintenance awarded by the military authorities was insufficient for her maintenance and for bringing up her daughter. Looking to the rate of inflation and expenditures to be incurred by respondent 11, the stance of the respondents 1 to 11 Union of India and other army respondents in their counter affidavit and reply to the delay condonation application and during arguments was that as per the applications by the respondent 11 and her father to the CO 69 RRC was being ill treated by her husband and in laws, hence she was living with her parents in MP. It was admitted that the applicant had submitted an application dated 30/8/2022 for stopping payment of maintenance to respondent 11, which was now pending consideration before the Eastern, and it was confirmed from the principal high school Jabalpur that she was employed there. Respondent 11's comments were shot by a letter dated 31/5/2022 as to why why her maintenance be not discontinued, to which she replied that the maintenance payment he maintained, as she was finding it difficult to maintain herself and her growing daughter, who was being educated on the meager income of a school teacher. As per investigation ordered by the competent authority, the respondent 11 had a take home salary of rupees 25,200, which which was insufficient for her survival. It was further contended that respondent 11 was not only entitled for maintenance for their survival as a human being is not consigned to the life of an animal, but is entitled to lead a life of dignity similar to how she was earlier living. It was further observed in the objection to the delay condonation application that the applicant had belatedly challenged the order dated 2022 without any reasonable explanation for the delay. Hence, the MA and OA observed to be dismissed on that ground also. In the light of the aforesaid contentions, and after considering the case law on point, we have examined the matter in hand. We find that so far as the order dated 2022 passed by the respondent number 11 is concerned, the said order does not appear to be suffering from any intrinsic illegality, as the said order appears to have been passed at the time when the respondent 11 was completely unemployed. In accordance with the provisions of law, after giving due notice to the applicant, has no plea has been raised by the applicant in his petition that the order was passed without opportunity to him. However, we are not inclined to dismiss the application on the ground of delay, as the applicant has not only challenged the order dated 2011-2022 but has also made a prayer in support of his application. The applicant, in view of her landing a job as a government school teacher wide order dated 22/1/2022, though the said job was also obtained more than 3 years prior to the filling of the OA, and also as the applicant has to make a recurrent payment for maintenance, the MA is therefore admitted and disposed of. We may now consider the OA on merit from the mere fact that the respondent number 11 has been unable to appear before the court on the dates fixed, or even to instruct her counsel to appear after receiving notice. It ought not to be inferred that the respondent 9, who is supporting herself and her 6 or 7-year-old daughter in MP Bhopal, was unable to personally appear to or to instruct her counsel to appear despite service of notice out of lack of respect for the court. But considering the series of litigations before the low civil court and the High Court in which she had been entangled by the applicant, she may no longer have the means to contest each and every case in the courts at Jabalpur and to instruct counsel with her meager resources. Hence, the prayer of the applicant cannot be allowed only on the ground that the respondent number 11 or her counsel have failed to appear at the time of final hearing. Also, we think that the matter needs to be investigated as to the capacity of the respondent 11 to maintain herself and her growing child, who is being maintained and educated by the respondent 12. The said investigation can be best carried out by the competent military authority. The submission of Mr. Chawla that maintenance is not enabling a woman to survive and lead on animal existence, but it is for providing a life of dignity comparable to her earlier living standards, is correct. In this regard, it has been held in Sohan Das versus Raja Ram 2018 6 SCC 354 at page 358 as follows. Be it ingeminated that section 226 of the Code of Criminal Procedure, for short, the code was conceived to ameliorate the agony, anguish, financial suffering of a woman who left her matrimonial home for the reasons provided in the provision, so that some suitable arrangements can be made by the court and she can sustain herself and also her children if they are with her. The concept of sustenance, sustenance does not necessarily mean to lead the life of an animal, feel like an unperson, to be thrown away from grace and room for her basic maintenance somewhere else. She is entitled in law to lead a life in the similar manner as she would have lived in the house of her husband. That is where the status and strata come into play, and that is where the obligations of the husband in case of a wife become a prominent one. In a proceeding of this nature, the husband cannot take subterfuges to deprive her of the benefit of living with dignity, regard being had to the solemn pledged at the time of marriage, and also in consonance with the statutory the law that governs the field. It is the obligation of the husband to see that wife does not become a destitute, a beggar. A situation is not to be maladroitly created, whereunder she is compelled to resign to her fate and think of life dust unto dust. It is totally impermissible. In fact, it is the sacro sacrosanct sacrosanct duty to render the financial support, even if the husband is required to earn money with physical labor. If he is able bodied, there is no escape route unless there is an order from the court that the wife is not entitled to get maintenance from the husband on any legally permissible grounds. The provision para 3G of AO 2022 cited by the learned counsel for the applicant also speaks of denial of maintenance to the wife only when she has sufficient means to maintain herself and her children. It does not provide the denial of maintenance only because the wife has some means and might be able to survive and bring up the child at the level of an animal existence. Para 4 F3 of the same army order further provides that, however, the amount of maintenance allowance may be increased up to 26% of the said allowances where the said child is dependent on the mother, who is not entitled to be maintained by the officer. Also, in a number of decisions, it has been held that the principal responsibility for bringing up and economically supporting a minor child lies on the father. It has been held in paragraph 40 as follows: under every system of law governing the society, father, being a natural guardian of the child, is under moral liability to look out after and maintain the child till he attains adulthood. The court, being the guardian of the minors, is required to ensure the welfare and well-being of the minor, and in discharge of such duty is under a duty of direct the father to maintain the child, even if the mother is having sufficient means to maintain the child, as the father cannot evade his moral and legal responsibility of maintaining his child. We also find that the appointment letter of the respondent 11th 12th 13th appointment as a teacher shows the appointment to be temporary, although learned counsel for the applicant contends that the appointment is more or less permanent, and none has appeared before us for the respondent 14 to contest this position, but the malaise malaise of irregular payments to panchayat school teachers is well recognized. Therefore, in view of the absence of representation of counsel on behalf of the respondent 15 to contest the case, and the need for determination of the issue whether the respondent 16 would be still entitled for maintenance or whether her daughter would be entitled for higher maintenance if maintenance is denied to the applicant in the aforementioned background, and in the light of Army AO 2022 and other relevant legal provisions, and as the competent authority has all the necessary powers to get the needed investigations done on the issues that arise in this case, we think that the better course would be to remand the matter to the competent authority, where the applicant's application for determining the respondent 16 1960s entitlement for maintenance in the changed circumstances is pending consideration in another decision. The principal bench at New Delhi filed by the New Delhi OA 59 of 2010 with MA 349 of to, 20,002 and MA number 440 of 2018, Lieutenant Colonel Pradeep Bhalabi versus Union of India and ORS decided on 25/4 2016, filed by the Land Council for the applicant along with his rejoinder affidavit, wherein the respondent had similarly found employment in a school. The matter was remanded to the army authorities for a decision in the matter within a fixed time frame after giving notice to both parties and taking into consideration the current facts about the maintenance of wife and her child in accordance with law. So far as the case laws cited by the Land Council for the applicant regarding the lack of option before the respondent to seek enlargement of the reliefs in the absence of a cross appeal and the failure on the courts to grant more relief than is being prayed for, we think that from a mere mention by the respondent number 9 in her counter affidavit and in her reply to the so cause notice issued by the army authorities dated 31/5/2018 that she has a growing daughter to maintain and is unable to make both ends meet out of her meager salary as a teacher. She is not setting up any cross case in any appeal, and as this court is also not ordering payment of enhanced maintenance to the respondent number 17 or her daughter and his stage. Hence, the case cited by the Learned Counsel for the applicant in this connection have no bearing on the matter in hand. It is for the competent authority who has plenary powers to whom the matter is being remanded to consider all these aspects as indicated above. The competent authority is therefore directed to take a decision on the aforementioned issues as far as possible within 6 months of the communication of the order. The applicant as well as the respondent number 18 may bring any further documents to the notice of the competent authority or raise any further pleas in support of their respective claims for a proper decision in the matter. With the aforesaid observations, the OA is disposed of. Stop.